I have made a lot of decisions in my life, some good, some not so good. I decided to become a contractor at 22 years old, and that turned out to be the right call. I decided to marry Linda when I was 26, and that was the best thing that ever happened to me. I decided to buy our house in Scranton when the interest rates were ugly, and everybody told me to wait, and that turned out fine too. But if you ask me today, at 63 years old, what the single best decision I ever made for my family was, I would not say any of those things. I would tell you it was the day Linda and I sat down with an elder law attorney and set up a revocable living trust. And I know how that sounds. I know that sounds boring. I know that sounds like something a financial advisor says in a commercial, right before they show a couple walking on a beach. But I need you to hear me out, because that one decision, that one afternoon, that one stack of paperwork is going to save my children from the nightmare that I went through when my father died. And I'm going to tell you exactly why. But first I have to tell you what happened to my family, because you can't understand why a living trust matters until you understand what happens without one. My father's name was Frank. He died in 2016 at 81 years old. He was a good man, strong man, honest man, worked hard every day of his life, kept his house in shape, paid every bill, never asked anybody for anything. And when he died, he left behind a house, a truck, a checking account with about $14,000 in it, some tools in the garage, and absolutely no plan for any of it. No will, no trust, no power of attorney, nothing. He just assumed his kids would handle it, that we'd sit down like adults and divide everything up fairly and move on with our lives. And I understand why he thought that, because that's what most people think. They think their family is different. They think love is enough to sort through the details. It's not. Love is not a legal document. Love does not tell a probate judge who gets the house. Love does not prevent your daughter from hiring a lawyer because she thinks her brother is taking more than his share. Love does not keep the government from taking a piece of everything you worked for before your kids see a dime of it. When my father died with nothing in place, everything he owned went into a process called probate. And I want to explain probate to you in the plainest English I can, because most people have heard the word, but don't really understand what it means. Probate is the legal process where a court oversees the distribution of a dead person's assets. If you have a will, the court uses your will as a guide. If you don't have a will, the court uses your state's default laws, which might have nothing to do with what you actually wanted. Either way, the court is in charge. Either way, there are lawyers involved. Either way, there are fees. Either way, it takes time. In my father's case, it took 2 years. 2 years of court appearances and attorney fees and paperwork and phone calls and arguments between me and my sister Diane about what to do with every single thing Dad left behind. The house was the big one. The house my father built with his own hands. The house I grew up in. The house where I learned to ride a bike in the driveway and threw a baseball against the garage door until the paint came off. That house sat in legal limbo for 2 years while Diane and I fought about whether to sell it or keep it or rent it out or what. And during those 2 years, the property taxes still had to be paid. The insurance still had to be paid. The lawn still had to be mowed. The pipes froze one winter because nobody was living there, and that cost $3,000 to fix. Money that came out of the estate. Money that could have gone to our mother. Money that was wasted because 2 adults who loved each other couldn't agree on anything because there was no plan telling them what to do. And then there was the bank account. $14,000. My father's checking account. That $14,000 became the thing that ended my relationship with my sister. I won't go into all the details because some of it is still too painful, and some of it is private. But I will tell you this. Diane and I have not spoken since the probate was settled. Not a word. Not a phone call. Not a Christmas card. Not a text message. Two people who grew up in the same house, who were raised by the same man, who sat at the same kitchen table for 18 years of their lives, and we are strangers now, because Dad never made a plan. And on top of all of that, our mother Ruth, who is 84 now and living in assisted living, she nearly lost her home because nobody had set up any kind of trust to protect her assets from long-term care costs. We eventually got a Medicaid asset protection trust set up for her, but it was almost too late. 5 years earlier, and she would have been fully protected. Instead, we were scrambling at the last minute trying to save what we could. That's what no plan looks like. That's what probate looks like. That's what happens when a good man with a good family dies and leaves nothing but love behind. Love wasn't enough. Now let me tell you what a living trust actually is and why it would have changed everything. A revocable living trust is a legal document that you create while you're alive. You put your assets into the trust, your house, your bank accounts, your investments, whatever you want to protect. The trust owns those assets, but you still control everything. You're the trustee. You can buy things, sell things, change things, take things out, put things in. Nothing about your daily life changes. You still live in your house. You still use your bank accounts. You still make every decision. The trust is just the legal container that holds it all. The magic happens when you die. Because when you die, the assets in that trust do not go through probate. They don't go to court. They don't become public record. There is no judge. There is no filing fee. There is no waiting. Your successor trustee, the person you name to take over, steps in and distributes everything according to your instructions. Quickly, privately, without lawyers and courts and 2 years of fighting. If my father had a living trust, the house would have transferred to my mother immediately, or to me and Diane according to whatever Dad wanted. No court, no argument, no opportunity for two grieving kids to turn on each other because there was nobody telling them what to do. That $14,000 bank account would have gone exactly where Dad wanted it to go, the day he died, not 2 years later after attorneys took their cut. And Mom's house could have been protected from the very beginning if it had been properly placed in a trust designed to shield it from long-term care costs. Everything, every single piece of the nightmare we went through could have been prevented by one document, set up while Dad was still alive and healthy and sitting at his kitchen table drinking coffee. When I learned all of this, when I finally understood what a living trust was and what it could do, I was angry. I was angry at myself for not knowing sooner. I was angry at the system for not making this more obvious. And I was angry on behalf of my father, who deserved better than to have his family torn apart because of paperwork he didn't know he needed. Linda and I set up our living trust 3 years ago. We found an elder law attorney, not a general practice lawyer, an elder law attorney who specializes in trusts and estates and probate and Medicaid planning. That distinction matters. A general practice lawyer can draft you a will. An elder law attorney can build you a plan. We sat down with him for about 2 hours the first time. He asked us questions I had never thought about. Who do you want to manage your finances if you can't? Who do you want making medical decisions for you if you can't speak? What happens to your house if one of you needs nursing home care? What happens to your retirement accounts when you both die? Do you want your children to receive their inheritance outright, or do you want to protect it from their creditors or a future divorce? That last one stopped me cold. I had never thought about that my son Michael could inherit everything Linda and I worked for, and then if his marriage fell apart, his ex-wife could be entitled to a portion of it. Our attorney explained that inside the trust, we could include provisions that protect our children's inheritance. The money stays in a sub-trust for their benefit. They can use it, they can access it, but it's shielded from lawsuits, from creditors, from divorce settlements. It's protected, for them and for their kids. When he explained that, I looked at Linda and she had tears in her eyes. Not sad tears, relief, because we were finally doing the thing we should have done 10 years ago. Here's what our estate plan looks like now. We have a revocable living trust that owns our house, our bank accounts, and our investment accounts. Linda and I are the trustees. When we both pass, Michael takes over as successor trustee. He distributes everything according to our instructions. No court, no probate, no waiting. We have pour-over wills. These are backup wills that catch anything we forgot to put into the trust. If there's an asset that somehow didn't make it into the trust before we died, the pour-over will directs it into the trust so it can be distributed according to the same plan. We have durable powers of attorney. If I become incapacitated, Linda can manage our finances immediately. If she becomes incapacitated, I can do the same. No court, no guardianship petition, no waiting 4 months like my neighbor Ed's wife had to do when he had a stroke and she couldn't access their own bank accounts. We have health care directives. If I can't speak for myself, Linda knows exactly what I want. And if she can't speak for herself, I know what she wants. No guessing. No family arguments in a hospital hallway. No guilt about making the wrong call. We have updated beneficiary designations on every account that has one. Every 401k, every IRA, every life insurance policy. All checked, all current, all pointing to the right people. And we have a letter of instruction. This isn't a legal document, it's a personal one. It's a letter that tells Michael and Sarah everything they need to know. Where the documents are, where the accounts are, who our attorney is, who our financial advisor is, who our insurance agent is, what our wishes are for the funeral, what hymns Linda wants, where I want to be buried, who gets Linda's mother's ring, who gets my father's watch, all of it, written down in one place. Because the worst thing you can do to your children is die and leave them guessing. Now I want to address something because I hear it all the time. People say, Harold, trusts are for rich people. Trusts are for millionaires. I don't have enough to justify a trust. And I want to tell you that is absolutely, completely, dangerously wrong. If you own a house, you have enough for a trust. If you have a 401k, you have enough for a trust. If you have children, you have enough for a trust. If you have anyone in your life who depends on you, or who will be affected by your death, you have enough for a trust. My father was not a rich man. He had a house that was worth maybe $160,000 and a checking account with $14,000 in it. That's it. That's what we spent 2 years in court fighting over. A trust would have cost him maybe $2,000, maybe $2,500, one time. And it would have saved his family tens of thousands of dollars in legal fees, 2 years of time, and a relationship between his 2 children that will never be repaired. $2,000. That's what it would have cost to keep our family together. He didn't spend it because nobody told him he needed to. I also want to tell you what a living trust does not do, because there's a lot of confusion about this. A living trust does not protect your assets from the IRS. You still pay income taxes the same way you always did. The trust doesn't change that. A living trust does not automatically protect your assets from nursing home costs or Medicaid. For that, you need a specific kind of irrevocable trust designed for Medicaid planning, and you need to set it up at least 5 years before you need care. That's a different conversation with your elder law attorney, and it's one you should have. A living trust does not replace a will entirely. You still need that pour-over will as a safety net. And a living trust is only as good as its funding. Funding means actually transferring your assets into the trust. retitling your house in the name of the trust, changing your bank accounts to be held in the name of the trust. If you set up a beautiful trust document and then never move your assets into it, you have a very expensive piece of paper that does nothing. Your attorney should walk you through the funding process and make sure every asset is properly titled. If they don't, ask. This is the mistake I see more than any other. People set up a trust and then don't fund it. And when they die, their family ends up in probate anyway because the assets were never moved. Don't let that be you. The cost of setting up a living trust varies depending on where you live and how complex your situation is. For a straightforward trust for a married couple, you're probably looking at somewhere between $1,500 and $3,000. That covers the trust, the pour-over wills, the powers of attorney, the healthcare directives, and the funding assistance. Some attorneys charge more, some charge less. Shop around, ask questions, but don't let the cost stop you, because the cost of not having one is so much higher. I think about my dad every day. I think about the conversations we never had. I think about the documents he never signed. I think about Diane and whether she thinks about me the way I think about her. I think about my mother in her assisted living facility and how close we came to losing everything she had. And then I think about my own family, about Linda, about Michael and his wife and James and Emma, about Sarah down in North Carolina. And I think about the afternoon we sat in that elder law attorney's office and signed our trust documents, and I knew in my gut that my kids were going to be okay. That when Linda and I are gone, whenever that is, our family is not going to be standing in a courtroom fighting over our house. They're not going to be waiting 2 years for a judge to tell them what they can do with their own parents' belongings. They're not going to stop speaking to each other over a bank account because we made a plan, because we did the thing that my father never did, and that is the best decision I have ever made. Better than buying the house, better than starting the business, better than any investment or any job or any financial decision I've made in 63 years of living. Because this one protects the people I love after I'm gone, and nothing else I've ever done can say that. If you don't have a living trust, get one. Call an elder law attorney this week, not next month, not next year, this week. Sit down with them, ask every question you can think of, and then go home and sit your family down at the kitchen table and tell them what you did and why you did it. That conversation will be one of the most important things you ever do. I'm Harold. I'm not a lawyer. I'm just a guy who learned this stuff the hard way so his kids wouldn't have to. And I'll see you in the next one.